Hi, this is Bob Bianchi from the Law&Crime Network. What we see is First State's witness Shane Hansworth discussing the robbery at the Quality Inn that ultimately led to the police solving this case, and that is the murder of a Marine. Two men are on trial for their lives. It's a death penalty case out of Kentucky, and it's the Quincinio, Canada case and the Dwan Mulazum. I'll get that name right eventually, Dan Schorr, from who's my guest here. Right now, they're discussing one of the most important topics of the day, and that is lunch. And you would not believe how much discussion and debate then goes on about the lunch period and how long it's going to be. And this really is an opportunity for the lawyers who really don't eat lunch. They go down there and they're working on their case. So what do you think is so far of this first witness, and what do you think the state's establishing with this? Right. They're trying to look. The whole case is about tying these defendants to this murder. So what they're trying to do is show there was a prior robbery, and that the gun that was used there and maybe one of the identification there can also tie one of these defendants at least to the murder that was occurred, I think, 6 days later or thereabouts. So they're trying to tie it in that way. Well, it's great. And you know what? Listen, today's like a huge day. I got Dan with me here. Mark Eiglarsh, how are you? It's great to see you. You join in on the conversation here, Mark. What do you think of this trial so far and the state's first witness? What are your general thoughts?
Well, I found one comment to be extremely interesting. In 25 years of litigation, when ID is an issue, almost 99% of the time, the witness says, I looked at the photo lineup and I was 100% certain right away that that was the person who held a gun to my face. In this case, his words were not that. They were, well, the longer I looked at the picture, the more it became clear to me that it was him. I can do a lot with that on cross-examination. Yeah, and Mark and Dan, we all know, and I always like to refer back to my person who taught me, my dad, 86 years old, always used to say, the number one way a person is going to be convicted of a crime they did not commit is by a bad identification. And for our viewers out there, the reason why that's really hard to cross-examine a person making a bad ID is that they are so convinced they actually identified the right person. Don't you agree, Dan? Yes. Now, in this case, you're right. It's unusual that he says, the more I looked at it, the more convinced I became. But there's also a ring of truth to that, because if he was going to lie, he would express more confidence. Now, he may be wrong, though. He might have, as he looked at it, more convinced himself. Certainly the case can't rise or fall just on this identification, but the prosecution's going to use this and hopefully, in their view, other evidence and piece it together to show these defendants are the right ones. Excellent. And Mark, you had indicated that you see a lot of daylight there as a great cross-examiner in terms of that kind of a weak statement. He eventually said, I 100% know. Where would you go tactically with this kind of witness in terms of trying to show the jury that this identification is not as solid as is being testified to in court? I would argue there's internal conflicts with what he's saying. He's 100% sure that's the guy. But wait a second. If you break down what he was saying, he wasn't 100% sure right away. In fact, he wasn't sure. It took time. So it's kind of like a graph. I'm not sure if it's him. I'm not sure if it's him. It probably is him. It most likely is him. Okay, now I'm 100% sure it's him. Well, what happened? What happened during that time period? Were you worried that you might say it wasn't him and then he'd get cut loose, and maybe it's the guy, maybe it's not? Mark, you're bringing up excellent points, and, there's also a lot of confirmation bias that goes on with these things. They kind of identify with being on team police and prosecution, and many times just convince themselves. But listen, I love you two guys as guests. We got so much to cover, but we got to go to these amazing top crime stories here at the Law&Crime Network, the only gavel-to-gavel coverage where you can get guys like Dan and Mark to be giving us their expertise in the tactics of trial work. So on the other end of the crime stories, we're going to come back and discuss this case a little bit more while we're on break. Welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be hosting until 3 o'clock. We got a lot on the table there, but I got Dan and Mark with me. I want to go with you guys on that last story, this trial horror writer story with Blake Label, who's 37 years old. And is this art imitating life? I'm curious as to what you guys think about to what extent the prosecutor is going to be able to use his horror books, because part of this case, in this graphic, brutal, gruesome case, is that he actually cut off part of the scalp, ear,
eyebrows, and drain the blood from the body, which apparently is part of a novel that he had written. I won't even mention it to give it any kind of, kudos out there if people want to go see it. But Dan, what do you think? Are they going to be able to use that information from that book to as proof, direct proof by the state?
I certainly think it's relevant. If someone has an unusual plan to kill someone, and this is certainly an unusual plan, and they have mapped that plan out in writing before, even in a fictional sense, that doesn't prove that they did it, but it's certainly relevant because it shows that this was in that person's mind. They knew how to conduct a killing in this sort of way. So absolutely, it comes into evidence.
So, Mark, let me have your defense lawyer hat on. If before we go to trial, I'm going to give you time to think now, okay? Before we go to trial and before you're in front of that jury, you can file a motion as a defense lawyer and say, hey, wait a second, Judge. This is a fictional work that's done, and to include that before this jury would be unduly prejudicial. What are your arguments to get that thrown out, or do you not want it thrown out?
Well, first, let me make clear that if Dan's the prosecutor, I walk over to him and I say, I wish I was the prosecutor in this case. So I agree with him 100%. Now you put me on the defense side, which is very good broadcasting, I would add. So now I got to put my defense hat and try to pretend I've been paid money to represent this guy. Yeah, I would say it's more prejudicial than probative. Judge, the minute that jurors hear about what's in his mind and what he put down, they're going to erroneously think that that's something that he agrees with, participates in. It's just his imagination. And it would be more prejudicial than probative.
Well, Mark, what you were talking about is an evidence rule, and I always love to talk about evidence rules here because, folks, for those who are watching, it's not a free-for-all in a courtroom. There are certain rules that we have to go by, and one of them is what Mark just mentioned. Typically, in most states, it's evidence rule 403, which means that there are some pieces of evidence that may be probative, but their prejudicial impact is and speculative nature of it is so wild that it could lead to confusion of the jury or shouldn't be admitted as evidence, and that argument is made all the time. Mark, you did a great job. You did the exact defense argument that you should, and Dan, you did a great job in bringing out the prosecution piece. Hey, folks, we're in the Kentucky versus Quincinio, Canada, and Dewan Mulazum murder trial. These are two individuals who were accused of murdering a Marine and by shooting him in the back and also injuring his wife while they were outside at the wife's birthday party. We have our first witness in this case, and he is Shane Hansworth. He was robbed at a Quality Inn, and the gun that was used was eventually connected by the police. But Mark and Dan, there were some great defense opening statements in this case. I want to go to a clip of one of those parts of the defense opening, and on the other side of that, I'd like you to put both of your prosecutor hats on, your defense lawyer hats, and tell me, one, I'm going to ask you, why didn't one defense attorney give an opening? And two, how effective was the one defense attorney that did give the opening? We'll catch you on the other side. Welcome back to the Law and Crime Network. We are on a break in this case, Kentucky versus Quincinio, Canada, and Dewan Mulazum. I have with us Dan Schorr and Mark Eiglarsh, who are great guests to have. I love this hour, this part where they're on break right now because I get great guests like you guys. Mark, let me throw to you first. There was a lot that defense lawyer said, and we know that many times defense lawyers are not that specific in their opening statements about things the police did do or didn't do. I think I know what you're going to answer was the most compelling thing that she claims is going to be shown, but I'm curious, what do you think was most powerful to the jury?
Can I criticize her first? I'm so eager. Here's my pet peeve. I teach my law students that either your client's guilty, and if you're the defense lawyer, that cannot be an option, or your client's innocent. Let's stop for a second. They want to take the life of an innocent person. What type of demeanor do you think should match those feelings?
Right.
Not what was oozing from this defense lawyer. I didn't believe that she believed it, and I will not start by crediting things that she said before I first say that, because that really troubles me. Okay.
Yes. So the next part is, what did you find compelling?
All right, fine. The part at the very end when you cut off where, again, I think I said it earlier for anyone joining us, the eyewitness is not certain, at least until a certain amount of time goes by, as he's looking at the photographs, that that's the one who robbed him. To me, that speaks volumes. That means he's not certain, and he had to convince himself, or something happened during that time period. That's not, I'll never forget that face. I'm certain of it. I'm 100% sure. I knew it right away, and I'll never forget it.
Well, Dan, I respect my colleague very much there, Mark. I train many trial lawyers myself, and the thing is that sometimes you can't put a square peg in a round hole. And what I mean by that is that sometimes the personality of the people trying a case is different. And so I'm on the very aggressive side. I'm probably very much like Mark. I would be yelling and screaming that you're trying to take a guy's life with this terrible evidence. But I've also found some very soft-spoken, more ethereal or, you know, to the point, not so much yelling and screaming, not so emotional, sometimes have been very effective. So what is your response to what Mark said? And my second part of my question, what did you find most compelling of the things she brought out as far as evidence is concerned?
Sure. Well, I think Mark makes some great points there. I know it's a different style than Mark describes, and I understand why you'd want to be outraged that someone hypothetically is innocent and being subject to a possible death penalty. But I did find her exuding confidence in the sense that she gave out a lot of specifics about why her client should be found not guilty. And so many defense closing arguments, or excuse me, opening arguments, are just about reasonable doubt and listen to the evidence and, you know, you look carefully at all the evidence, and at the end of the case, I'm going to say there's reasonable doubt. She was actually giving specifics that the ID might be tainted, that there was DNA under one of the victim's fingernails that didn't belong to the defendants, and all these other reasons, specific reasons that you don't see in a lot of cases. And to me, that was very compelling, and the prosecution certainly will have to address all that.
Well, I'll tell you, mine was, no, the DNA doesn't match. I thought that was compelling. But, Mark, we'll have to get back to you on the other end of this because we still have a little bit more of the defense we have to get to real quick for our listening and viewing audience. And on the end, we'll come back and get your point and discuss a little bit more. We're at Kentucky versus Quincinio Condata and Dewan Mulazum. And here is more of that defense opening statement. Welcome back to the Law and Crime Network. We're taking these defense openings bit by bit because I got two experts with me, Mark Eiglarsh and Dan Schorr. Listen, guys, I just think she's doing, I did a little informal poll. I think she's putting out some points here. For a defense lawyer, she's not just doing the American flag and presumption of innocence and reasonable doubt. She is getting specifically, not only will she show the evidence says, but she's also talking about the failure of the police to do a number of things and even waited years to do certain things. I personally think she's kind of effective. Mark, I know you had a point you want to bring out. What do you think?
Well, I have a new point and I have an old point. First of all, when did the bar become so low to call someone effective when they're actually talking about the evidence? Really, that's all it takes, Bob? Come on, buddy.
Hey, Mark, listen, brother. Listen, brother. I've been trying cases probably longer than you've been on Earth, and I know good lawyering. And the fact of the matter is, you do not hear opening statements by defense attorneys that are getting so specific about the failure of the police to do things and making assertive statements. I've been around, brother. I teach just like you do. I think she's doing a good job.
What are they saying? Listen, substantively, let me make clear. Substantively, I like a lot of the points she's making. The point I made earlier was not about necessarily style, in that some could be very over the top and animated, and some could be very reserved and soft-spoken. But what I'm referring to is passion. I look into an attorney's eyes, and regardless of whether they're over the top or in the middle or very soft-spoken, I look in their eyes and I ask myself, do I believe that they believe what they're saying? She looks like someone who's imitating someone who's representing someone. She doesn't look like she actually feels that her client is innocent. That's all I'm saying.
Okay, fair enough. What do you think about that, Dan?
Well, I mean, I do believe that she believes it, so we just see it differently. But I agree with Mark. There is a low bar here because most defense arguments that I've seen in opening statements don't present evidence. And I know to praise someone for presenting evidence and facts, maybe that is a low bar, but I think that's where we are, that most defense attorneys, when they get up, they don't know why their defendant should be acquitted, but they make that argument, reasonable doubt, he has a right to remain silent and all of that, and they don't get into the specifics of the prosecution's case and what the flaws are, and she's doing that. So this is more substantive than I would say 95% of the defense arguments I've seen. Maybe that's a low bar, but that's what I've seen in my experience.
Okay, guys, I know we got a lot to talk about. It's going to be hot. I love it. But let me ask you, I'm going to throw to you, Mark. What do you think about the idea that the one defense lawyer didn't give an opening statement? Good move or bad mover? Can you make sense of it?
It's a smarter move, in my opinion, if that defense lawyer knew the other lawyer was going and obviously knew what that lawyer was going to say. Then they could keep it close to the vest, and if they want to, give one later. I don't know what the thought process is, but I can't condemn it.
Mark, something tells me about you, and I don't know you well, but something tells me you have never said in a courtroom, I've got nothing to say, Judge, in an opening or closing, that Mark Eiglarsh is getting up there and he is going to knock it out of the park. No?
Not only are you correct, Bob, but I consider it an opening argument, not an opening statement. My openings are very similar to my closing arguments. And if that nimwit objects, I just say, oh, the evidence will show.
Oh, my God.
And then I go back to my closing opening argument. And that's what
we got to try a case together, because I get that all the time. Judge, he's summing up, and I'm like, no, I'm saying the evidence will reveal, but I'm doing it just like a summation. I love it, Mark. How about you, Dan? I mean, can you make sense of why it is that the lawyer wouldn't take advantage, like Mark and myself are basically saying, of having your first crack at giving basically your closing argument to the jury?
It's hard to tell, because I do think it's an opportunity. Not only do you want to present the evidence the way you see it, but you also want the jury to get to know you as a person. Part of an opening statement is to get them to like you, to trust you, to build a rapport with the jury. And you get that by looking in their eyes, talking to them. And so it's a wasted opportunity not to take advantage of that. Maybe on the evidence, the other defense attorney felt this defense attorney covered all the bases for both defendants, and that was sufficient. But I certainly would disagree with that as a tactic. You want them to hear your voice, get to know you, get to like you, and get to trust you, hopefully.
Well, listen, if it were me and I were inclined not to do it, I would at least get up and say, let me just tell you something right now. Hello, no DNA under the fingernails. Thank you very much. Sit down, at least at a minimum. Guys, I'd like to continue this story with Mark, this case with Mark and with Dan, but unfortunately or fortunately, we're going to go back to the defense opening. Obviously, this defense lawyer is sparking a lot of debate between us. Mark, we're going to catch you on the other side of this. Dan's in studio. We'll see more of the defense opening right now. Welcome back to the Law&Crime Network. I am Bob Bianchi. I will be here to 3 o'clock with you. I have my great guest, Mark Eiglarsh, and in studio with us, Dan Schorr, a new trial analyst of the Law&Crime Network. We are looking at the defense opening statement in Kentucky versus Quincinio, Canada, and Mulazum, Dwan Mulazum, two defendants who are on trial right now for their lives. It's a capital murder case. The prosecution did their opening. One defense lawyer chose not to do an opening. This lawyer is doing one. We're having a little bit of a debate here as to whether she's doing an effective job or not. But let me go to Dan first on this. What did you think about the point that they never took, apparently, during this struggle? There was some DNA evidence under the fingernails, and they never even submitted it to the lab. Is that going to be a significant fact in your mind, Dan?
It's certainly something that the prosecution has to explain. If there's DNA under one of the victim's fingernails and it doesn't belong to the defendants, why didn't that come out earlier? And whose DNA was that? She should know the universe of people who that DNA could belong to. She is a surviving victim here. She could talk about everyone she's touched in the last couple of days before that, and you think you'd be able to identify, well, whose DNA was this, if not these two defendants, if those two defendants were the ones that assaulted her?
Well, Mark, you know as well as I do, at the end of a trial, a judge says that you can find a person not guilty based upon a lack of evidence or the failure of the police or investigators to do something they should. And in today's day and age with DNA, there's DNA databases, there's all sorts of transfer that occurs during a struggle and during one of these kind of encounters. Do you think that that is something that is problematic for the prosecution in this case?
Huge. I would make it the centerpiece of my case. I would say, how dare they put you in a position where you have to guess whether these eyewitnesses are being accurate.
Right.
Science doesn't lie. Science doesn't make mistakes. And all they have to do right now is submit it to the lab, and we would know it wasn't my client who did it.
Right. So, Mark, you maybe a little bit in line with me that maybe an effective opening for the guy or the person, the defense lawyer chose not to open is to say, never submitted DNA under the fingernails of the person, still haven't done it, and ask you to push a button and kill my client? I don't think so, and just sit down. Good?
I like every single thing you've come up with, Bob. Any other alternative than sitting on your ass and doing nothing seems to be more effective.
Amen. Hey, listen, I got Mark Eiglarsh with us and Dan Schorr, trial analyst with the Law and Crime Network. We could go on and on, I could tell, with this crew, but we're going to go back to one more clip of the defense opening, and on the other side of that, ask these two characters some questions about that. Welcome back to the Law and Crime Network. We are listening to the last clip that we're going to do for this period of time in Kentucky versus Quincinio, Canada, and Dwan Mulazum. I got our great guests with us, Dan Schorr and Mark Eiglarsh. We've been having a real spirited and great tactical conversation about the defense attorney's opening statements, sometimes agreeing, sometimes not. I got to ask you guys this question. It's not really a legal question, but it's about presentation in front of a jury, and I know you guys do it, and Mark, you teach it as I do. What about these examples about a river and bridges? I've heard everything about pea soup, minestrone, all these examples to try to talk to a jury about reasonable doubt. Dan, do you think that kind of stuff is effective, or is it just a tad too hokey for a jury?
I don't know. It's too hokey for me. Maybe some juries like it. I kind of like just sticking to the evidence, showing why there's reasonable doubt. But I know that juries have a hard time wrapping their heads around what is reasonable doubt, what is not reasonable doubt, and to give some analogy or some explanation that is maybe more vivid may help them. But hey, I've never been a defense attorney, so that's not my area of expertise. You
know, if it were me, the only bridge I would be talking about, Mark, is I would be just sitting there saying they're trying to put a bridge here. But I'll tell you what the defense is going to do in the case. We're about to blow it up. And I'd be very direct and very confident. What would you be doing?
Well, I'm not going to condemn her for that either. I don't use any kind of metaphors for reasonable doubt. I go right to the jury instruction because I know they're about to hear it, at least in closing arguments anyway. Mm-hmm. And I'd like to track the language. And I think there's enough language in there that's straightforward that I can spell it out for them. Mm-hmm. But I will tell you that in this case and almost all ID cases, I do use a metaphor and I do take them into a restaurant. And I would ask them, as I ask all you two, have you ever gone into a restaurant and they don't serve you water or bread right away? And you would say, yes, sure, that's happened to me. And then you go over to the waiter, or the waiter comes over and says, excuse me, can we get some water over here? We're really thirsty. He says, okay, I'll be right with you. And then 5 minutes goes by, excuse me, waiter, can we get that water that you promised? Yeah, okay, I'll be right with you. Then 10 minutes go by and you say, listen, waiter, we've been waiting here. We are parched. Can we please get some water? Now, anyone around you would erroneously think that that's your waiter until he looks down and he says, I'm not your waiter. And that's to highlight that there's a difference between believability and accuracy, that you can believe that that's your waiter at that moment, but you're completely inaccurate. So when this guy looks down, he says, that's the guy who robbed me after minutes or however long it took him to agree to that point. He may be believable, but he might not be accurate.
Well, Mark, not bringing bread to the table is a capital offense in an Italian family, I can tell you that. And I get your analogy, but unfortunately at this point in time, we're going to throw to a break for about 2 minutes. And when we come back, we're going to go probably to the prosecutor's opening statement. I like that we did it this way, defense first. Here we are with the break. We'll be back in a minute.
Okay.
Welcome back to the Law and Crime Network. My name is Bob Bianchi, and we are looking at Kentucky versus Quincinio, Canada, and Dwan Mulazum. We've had the pleasure of having Mark Eiglarsh here to give us some very spirited and interesting and great professional commentary here. Mark has to go, unfortunately, but Mark, I'm going to let you have the last crack. What do you got to say is the last comment before you sign off, and be back soon?
I think that the prosecutors will have an easier time with this case than you've had with pronouncing the names of the defendants.
I'm not going to get it right the entire trial, and that, I guarantee you are right beyond a reasonable doubt. Thank you, Mark. Listen, right now we're going to go to the prosecution opening statement, and on the other side of that, I have our guest Dan Schorr, who is a legal analyst here at the Law and Crime Network, and we're going to break that down for you.